what is worse about you having a hard time with studies is that you accepted the offer. You applied and said you want to be in varsity. So you know what? Let's do this. Yep. Let's get into the studies. Guys, welcome back to my YouTube channel and welcome to the night shift. Guys, it's getting colder and harder to prepare assignments because I'm just like, I'm not a UNISA student anymore. Why should I suffer? They'll figure it out. It's cold. It's cold, Disham. But anyway, let's just get right into the night shift. I don't know what time you guys are gonna get this, but this is the night shift, as you can see. As you can see, I'm just ready to just record this and go to sleep because what? No man. I am in disbelief. So I woke up around, is it 2 or 3? Well, it's a morning shift, in the morning, and I saw 6,000 subscribers. Thank you so much. Thank you so much. I really appreciate it. Thank you for sharing my channel. Thank you for making my channel recommendable. Thank you for making it interesting enough. I am because of you guys. I made a post the other day and I said I am because of you. Like this channel, for me to wake up even in this cold, even though I'm complaining and do this, it's because of you guys. You guys, your engagement, it makes me feel that if I don't keep doing this, then I'm not contributing to this community. Okay, so no matter how cold it is, siyabangena, rabatsena, until exams. Anyway, guys, we're going to do part 2, which is the last part of PVL2601. That is assignment 2. We're doing part 2. And question B reads, I answered there, it says, is Mr. Mukiza correct that all matrimonial property belongs to him alone? And I answered previously and I said no. But now the question said that I must answer and give reasons for my answer. So I'm saying no. Ngithe no, cha. I'm saying no because in the South African law, a default matrimonial property regime is community of property. When people get married like they pay lobola, automatically they are in community of property. That is the automatic one. So this means automatic. This means that if people get married without an antenuptial contract, it means they are automatically married in community of property. So no way that there's no way that all the assets belong to him alone because they got married without an antenuptial contract. Now, Mr. and Mrs. Mkiza got married in 1977 without an antenuptial contract. Therefore, their marriage is in community of property. This means that all assets Mr. and Ms. Mkiza owned before the marriage, as well as those acquired during the marriage, form part of the joint estate. So this means both Mr. and Mrs. Mkiza have equal undivided shares in matrimonial property, regardless of whose name the assets are registered under abafana. Hey! Or who acquired them. So this thing, hey, this coming April, if you do not have an antenuptial contract, you know what the danger is. Even the ones you did before her, phakathi inside. Now we see. I can now all of us we are making our things. Even the YouTube channel, it's property. It's how. What do you mean? Yes, I honor your baby here. When you're married in community property, right? So that is the reasoning. Therefore, I get you're gonna say no and give your reasonings to say, hey, like it's automatic. If you don't have an antenuptial contract, sangena phakathi, profit, loss, liabilities, you are in, you are sharing. Oh, and people do it these days. People just want their ring. Even if this guy's got 4 baby mamas. Lena dangerous, man. So you're going to say no and state that if people get married without an antenatal contract, say gunjalo. And then you explain, you apply this to the scenario. They got married in 1977 without an ANC. So this means that profit, loss, during, before, parity inside. How? Now, therefore, you're going to agree you have applied. Therefore, you are concluding Mr. Mkiza's claim that all matrimonial property belongs to him alone is incorrect. Both spouses are, I love it, are entitled to an equal share of the joint estate upon dissolution of the marriage. Right, so let's move to question 2. Mr. and Mrs. Daly entered into a civil marriage in communal property in 1983. 3 children were born from the marriage, two sons, Ivan and Sean, and a daughter, Camelia. Mrs. Daly's joint estate had Mr. and Mrs. Daly's joint estate had a value of 1 million. Mr. Daly died testate. It died with a will. His will reads as follows: I leave 30% of my estate to my wife, 50% of my estate to be shared equally among the children born of my marriage. I leave 20% of my estate to Miss Betty, my lover. Yo! Guys, I mean real people. What do you mean? It's giving Sister Bettina as hey, Mr. Daly. No further provision has been made for Mrs. Daly in Mr. Daly's will. Mrs. Daly is 50 years old and has been a housewife for the duration of the marriage. She fears that she will be unable to maintain herself from the money she is entitled to according to the will and in terms of the matrimonial property system, according to which she and Mr. Daly were married. Mrs. Daly approaches your law firm and seeks legal advice as a widow. With reference to legislation and case law, advise Mrs. Daly whether she can claim maintenance from Mr. Daly's estate, and if so, which factors will be considered in determining her claim. You need not to discuss the ways in which her claim, if any, can be disposed or be settled. Right? So, advise Mrs. Daly whether she can claim maintenance from Mr. Daly's estate. Okay, Juanyo. Abafana basithandi. Hayi shem. Let's see. Okay. So obviously the legislation here, already the question 2 tells you is the maintenance one, but which one? Now, with reference to the Maintenance of Surviving Spouses Act 27 of 1990, a surviving spouse has a right to claim maintenance from the deceased spouse estate, provided that the marriage was dissolved by death after 1 July 1990. The Act applies regardless of the matrimonial property regime that governs the marriage or whether the surviving spouse inherits in terms of the will or not. Here's what according to Section 2, subsection 1 of the Act, a surviving spouse may claim reasonable maintenance needs from the deceased estate until death or remarriage if they are unable to provide for themselves from their own means and earnings. This includes their share of the joint estate, any inheritance, and any other available financial resources. Case in point, OSHRY versus FELDMAN 2011. The Supreme Court confirmed that maintenance claim is a statutory right and arises automatically on the death of a spouse, and that courts must consider the totality of the circumstances to ensure the outcome. Guys, it's your full day every day, ne? So did you hear? Yeah, from the estate you can claim. Whether you are married in an hour or out, or you are married on a tree, it doesn't matter the matrimonial system. Now, we are going to look at, to apply this to Mrs. Daly's case. So, we are going to consider the following factors. The value of the estate. Mr. and Mrs. Daly were married in community of property, meaning she is automatically entitled to 50% of the joint estate, which is $500,000, right? Provision in the will. The will gives her 30% of Mr. Daly's. The will gives her 30%, her 30% of Mr. Daly's half of the estate, which is 150,000. Her means and earnings. Miss Daly is a 50-year-old housewife with no independent income or estate. Her financial needs and obligations. We are looking at the factors. She has ongoing living expenses and potentially health or housing costs that she may not be able to meet from her share of the estate and the inheritance alone. They were married for over 40 years, which is a substantial period and suggests deep economic interdependence, right? As a long-term housewife is in a stable marriage, her standard of living would have depended on her husband's income and estate. The fact that the portion of the estate was left to a third party, Miss Betty, the deceased lover, and not to the financially dependent spouse, may influence the court's decision to grant the maintenance order. So this is the fact. Given her age, lack of income, and a status as a dependent spouse, she may successfully claim maintenance under the act, because the lover who was given that 30%, it wasn't really necessary. So Miss Daly can lawfully claim maintenance from Mr. Daly's estate under the Maintenance of Surviving Spouses Act 27 of 1990. The claim is independent of her inheritance and the matrimonial property regime. So she can always claim maintenance. Plus, why is Betty getting anything? Where was Betty when she was ironing? Hey, Abafana. I keep telling you, go to boys. Abasifuni. Yes. Your boys, we are just forcing sham. We are just forcing sham. Anyway, guys, I will see you on the next video. I love you so much. Have a fabulous day or evening. I don't know what time you're gonna get this. I'm tired. I will see you in the next one.